Yes, I'm connecting to the other talks before me in giving a concrete example, and perhaps we can come into discussion about what was said before about, yes, the empowerment of diversity and codification being a kind of fossilization. My position is somewhat different. But first I start with regulating Sharia in Palestine, some interesting legal and political developments, at least I think. I have to start to say that I use the word Palestine or State of Palestine in the use of the UN, the United Nations, since 2012. They talk of the State of Palestine, and that's what I stick to. Now, on March 18, 2021, President Abbas issued a decree law, Qarar bi-Qanun, number 8/2021, which was immediately published in the official gazette, replacing an older decree law from 2012. And this new decree law regulates the Sharia judiciary and strengthens the position of the Supreme Muslim Judge, the Qadi al-Qudat, who, since 2014, has been Mahmoud al-Habash, a very conservative Muslim jurist when it comes, for example, to women's rights. Azam Abdin, a jurist and member of Al-Haq civil society organization, which was currently, or 2 days ago, closed down, regrettably, by the Israeli occupying forces. A very critical civil society organization, on his Facebook called this decree law a legal massacre, and criticized that it gave the Supreme Judge complete control of the whole Sharia judiciary. As the Sharia courts are Palestine's family courts, and as the Sharia judiciary plays an important role in Palestine with regard to the family law, my aim is in this talk to understand this new regulation as contained in this decree law of 2021 with regard to legislation, especially legislation in the realm of family law. Oops, no, I did something wrong. Yeah. So these are my two questions. What is new in Decree Law 8/2021, and why? How does it strengthen the Supreme Judge's position or the position and role of the Sharia? And the second question, what does this mean for the process of developing a Palestinian personal status law? There is no Palestinian law so far. I'll come to this. I have to start with this is my introduction, that then I have to give a very short introduction into the legal system of Palestine, and then I'll talk about the decree law and come to my conclusions. Now, this is already too far. The Palestine has a rich legal history, which is reflected still in today's legislations. Law and legal regulations of the Ottoman time, of the British Mandate time, of the Jordanian-Egyptian occupation exist side by side with Palestinian laws issued after the establishment of the Palestinian Authority in 1994. Israeli military law, international law, as applicable laws exist, as well as Islamic law and several disguises. I'm sorry. There's one missing. Oh, okay. And of course, international law, as I said before. In addition, the Christian churches have their own family codes, the actual codes in force, and this is important, and I think this is missing here. No, yeah, it was before, I don't know what happened. This is important. The applicable law in the West Bank is the Jordanian law of personal status from 1976, so a very old version, and in Gaza, the Egyptian family rights law of 1954. In Jerusalem, it's a new version of the Jordanian law from 2019, which is applied. With regard to international law, it has to be mentioned that on April 2, 2014, the State of Palestine signed CEDAW, the Convention of the Elimination of All Forms of Discrimination Against Women, the so-called Women's Convention, without any reservations. With this step, the Palestinian Authority demonstrated its willingness to the international community to apply human rights in a future state of Palestine. Doing this, the PA refers to Article 10. I go here. This is the CEDAW, as you all know it, and Article 2, which talks about to embody the principle of equality, and in the Arabic version it's musaba of men and women in their national and constitutional and other appropriate legislation. Of course, as I just said, the very outdated and old laws are not based on equality for men and women, not at all. doing this, the PA refers to Article 10 of the Palestinian Basic Law, which says in number 2, what happened to the text there? I'm questioning something went wrong. Can I have? Yeah, I'll go on like that. It's okay. So the Palestinian National Authority shall work without delay to become a party to regional and international declaration and covenants. Sorry, I have to go back. Yeah, this is the end of the quote. In Decision 4, 2017 of November 19th, 2017, the Supreme Constitutional Court in Ramallah ruled in its majority that, I quote, international treaties are above national legislation, end of quote. Thus, international law is rooted in the Palestinian Basic Law, as the Sharia is also, because in Article 4, we have number 2, the principles of the Islamic Sharia shall be a principal source of legislation. So in the case it's a and not the principal source, as in the Egyptian constitution, which means that, yes, there has been a lot of debate in Palestine about this being only a and not the source of legislation. So still there is a tension between the Article 10, which I just mentioned, and of course, and this Article 4, which makes the Sharia the basis. Palestine faces, in addition, of course, you all know the serious problems with regard to its legislative activities, because the parliament in Ramallah did not sit since 2006, when Hamas won the national elections and a conflict broke out between Fatah and Hamas. Palestine was split. You all know this. Hamas since then is controlling Gaza, Fatah the West Bank. And this is the reason given why President Abbas can issue decree laws, all of which have to be checked by the parliament when it comes together for a meeting again, but he postponed the elections. And according to the basic law, this is his right. Article 43 gives him this right to do so, but interestingly, he has not done this with regard to a family law, so he has not issued a family law so far. Now there is another player in the field which takes over, and this other player is, as I would argue, the Sharia establishment. It issues ta'amimat. What are ta'amimat? I even don't know how to translate it. You can translate it as regulations or circulars. I know, Ido, you have published on it, and your article is on the top, but I haven't had time to read it. I think these kind of circulars are quite interesting in this context. This now is a circular of 2012, and it concerns what we just had before in your paper, Jocelyn. The Holle, which is made now possible for women against the husband's wish. Because in classical law, it's of course not possible to have it against the husband's wish. You could interpret the text like this, but the Fuqaha didn't do it in the 1400. They didn't do it in the Mazhabs. It was completely discussed under.
Depends. I know cases.
Can I finish my post? You can please. I'm sorry, I didn't bring in. Yes, but of course, I mean, I know a little bit the classical Islamic law too, and you could interpret it differently, but you didn't do it.
Don't put me in the discussion.
No, I just say that you just mentioned the whole. Okay. At least in Egypt, it was it created a chance for women to go to court and get divorced against their husband's will. This is not completely the case in Palestine. It allowed women before consummation of the marriage to go to the court and get rid of the marriage contract. It helped young women in Palestine. It was therefore welcomed not only by the Sharia establishment, but also by the women organizations. Now, we could ask, can the Supreme Judge be seen as a de facto legislator? This is provocatively. What is the role of these ta'amimat circulars? And as mentioned above on a more general level, who should draft a future Palestinian family law? In the past, it has to be said that women's organizations had submitted many drafts to the Ministry of Justice. Lynn Welshman worked on this, and my new book is also about this, but without any success. So where are we now? What does decree number 8, 2021 say about this? So this, sorry to clarify these questions, can you be seen as a de facto legislator? What are ta'amimats and who should draft the future Palestinian law? You see here on the right side Mahmoud al-Habash, the Qadi al-Qadat for the moment, and the left side, this is the Women's Center for Legal Aid and Counseling in Ramallah, a very active women's organization. So decree number 8. The Sharia judiciary, al-Qada al-Shar'i, is according to Article 4 of this decree composed first of the Supreme Judge himself and his department, the Supreme Judge Department, the Diwan. Second, the Sharia courts, consisting of the Sharia courts of first instance and the Sharia courts of appeal and the Sharia court Supreme Court, Sharia Supreme Court. The Supreme Judge now holds in this constellation the following position. He is, of course, head of the Supreme Judge Department, the Diwan, and according to the same article, he has the rank, this is quite strange, the rank of the head of the Sharia Supreme Court. It's in Arabic, يكون بدرجة رئيس محكمة العليا الشرعية, according to Article 10. Now, going on to the institutional setting in this decree, Article 2 says that there is a guarantee for independence of the Sharia judiciary. This is a bit strange because you have a guarantee of independence of the complete legal system of the judiciary in the Palestinian basic law, but here it's said again. And of course, according to Article 5, the Sharia judiciary has its own budget. The Supreme Judge has, as I said before, the rank of a minister. No, as I didn't say before, it had in the first decree in 2012 already the rank of a minister. He was named as a minister by the president, but now his salary is even higher. He has no judicial status, but he has a higher salary than the head of the Sharia Supreme Court. This is quite interesting, and this has been he has been criticized very much. Abbas has been very much criticized for being in this fact. According to Article 1, he is the person authorized to administer the Sharia judiciary, al-Qada al-Shar'i, in accordance with this decree. To this purpose, he is named Qadi al-Qudad. And as in the old law, 2012, he thus represents the executive authority, and not the judicial one. He's not a judge. Now, interesting is Article 32, which regulates the establishment and composition of the Sharia Judicial Council, the Majlis. The Supreme Judge, here again holds an important position. He is head of this Sharia Judicial Council, of the Majlis, whereas in 2012 the president of the Supreme Sharia Court was the head of this Majlis, of the Sharia Judicial Council, and the deputy, the Supreme Judge, was the vice president of this Supreme Judicial Council, the Majlis. Now the Supreme Judge holds this position, so he got this position in addition, and the president of the Supreme Court is now only the vice president of him. The composition has changed a little bit. Just to make it short, it can be said that out of the 9 members of the Sharia, of the Majlis, of the Sharia Judicial Council, are named by the Supreme Judge himself. So this is quite a lot of power which he gets. So, yes, that's what I said. According to Article 35 now, the Sharia Judicial Council has the task of recruitment of the Sharia judges and their assignment and seconding them. With regard to all these tasks, the Supreme Judge holds now an extremely, of course, influential position. I think we see this. Now, when it comes to legislation, the Supreme Judicial Council's task is, among others, to draft a Sharia code of conduct for the judges, according to Article 35(1)(c), and it has the right to express an opinion on draft laws that regulate any matter of the Sharia judiciary, Article 35(1)(f). Thus, the Sharia Judicial Council has now officially gained the right to express the opinion on a family draft law for a Palestinian family law to come, hopefully. Article 11 of Decree Law is even more interesting because it says the Supreme Judge has to administer the Supreme Judge Diwan and sign all correspondences, decisions, qararat, instructions, and ta'mimat. So, however you translate them, circulars or rulings, or de facto law, to make it prohibitively, he now has the right to do it, and of course other documents. Now we come back to Isam Abedin and to my conclusions. As he criticizes, I read what he wrote.
Al-Habash, whom the president before had appointed as supreme judge in the rank of a minister, now became also head of the Supreme Judicial Council and was promoted to the rank of the head of the Sharia Supreme Court. He started to control with this decree all small and great things in the Supreme Judicial Council, as well as in the Sharia Court, in the Supreme Sharia Court. And the Sharia courts, with their ranks of judges and recruitments and promotions, transfer and assignment in departments and in general secretary, as well as financials and administrative issues, judicial control, taftish qada'i, and disciplining, ta'adib. And above, who retires and who gives exceptions. With this, Al-Habash combines the executive and the judicial power in the Sharia judiciary and controls everything in addition to financial privilege for Al-Habash, for Al-Habash, because he receives now an income of a president of the Supreme Sharia Court, and this is higher than the minister's income, end of quote. So this was a harsh critique of Islam and Adif Abedin al-Haq NGO. These are the two gentlemen, Abbas and Al-Habash. My conclusion is now Sharia judiciary gained officially the right to develop the personal status draft law, civil society out of the game. So we have to discuss, or we have to wait. We cannot discuss this, we have to wait and see how it develops. But I'm quite afraid that there will be any development towards a Palestinian family law so far, despite the fact that Abbas signed 2014 the CEDAW. And until there is a Palestinian personal status law, now the Sharia judiciary and the Supreme Judge has the right to issuing of circulars, quasi-legislation. So, yes, yes, I think I end here. We can leave the rest for the discussion. I think it's a highly interesting development. But what I wanted to show and to say is, with regard to this ta'mimat, Islamic, how do you call it? Not legislation, Islamic, it's ijtihad which comes in. So the prior Qadi al-Qudat, Yusuf Aqis, he used to say when he gave this ta'mim with regard to Qul, I'm mujtahid. And I see that there's a problem in the society, and of course I'm obliged to help people. Of course we don't have a parliament at the moment, so I give this ta'mim as de facto legislation to help women. Actually, it was in this case really welcomed by everybody in the Palestinian society. But it's a power of the Supreme Judge to, yes, be something like a mujtahid before. This is a bit provocative at the end for the discussion. Thank you.